Great. Good morning, everyone. I see people are still joining the room. It's my pleasure to welcome you on behalf of the Starlight team. My name is Nino Ceretelli. I'm a program coordinator representing Democracy Reporting International, and we are working in the Starlight project together with the Hungarian Helsinki Committee and the Heritage School. Starlight is funded by the EU's Citizens, Equality, Rights and Values, or SERV program. We are, as you may have guessed, in the second iteration of this program. The first was running between 2022 and 2024, and we trained over 100 lawyers through this iteration, and now we are in the second iteration running from 2025 to 2027. We've already trained around 40 participants in the first cohort, and now this webinar opens the call for application for the second cohort. We will be recruiting between 40 and 50 participants in this cohort. And today's event has two goals. The first goal is to increase awareness of the Charter and its potential among the legal professionals. And for this reason, we have 5 fantastic speakers with us, with whom we will engage throughout the first hour of our webinar, and we'll discuss various topics, successes, failures, lessons from using the Charter, and then also some of the recent developments in Hungary, across the EU, etc., and what they mean for Charter-based litigation. And then in the second part, sort of in the half an hour that remains after one and a half hour webinar, then we'll present the program. My colleague from Heritage School, Georgia Ann Langton, will be presenting the program. So who can apply, what the process looks like, and timelines, key dates for some of our events, including in-person workshops, etc. So you will learn a lot and you'll be able to ask questions. So there will be 2 parts where you can ask questions. First, at the end of the first hour, you can use the Q&A function or chat, and you can send us your questions, and then you can also ask questions about the program itself. We will share the call for applications in the chat, which outlines all the aspects of the program and also how to apply, where to register, etc. And you can also, we indicate the contact email so that you can reach out if you have further any questions in the later stages. The call opens today and you can apply anytime until 20th of September. We will explain a lot of that also throughout this webinar. The starting point for our discussion is that the Charter of Fundamental Rights, EU Charter of Fundamental Rights, is being increasingly used, which is great, but at the same time, we still see that the lawyers struggle to invoke it and also to follow up in terms of implementation of the Charter-related rulings. Sometimes judges are reluctant to refer, or if they refer and then apply the guidance of the Court of Justice, then we still don't see systemic change at the level of the entire judiciary or political level. And we have examples that Charter can be a very powerful tool, but only in the hands of those that can use it. And so with this program, and we will explain it further, we are trying to improve the knowledge and skills of the legal professionals to use the Charter and also create the community and the space where the participants are able to learn, exchange strategies, and transform individual efforts into more EU-wide impact. And so we will be really discussing throughout the program when to litigate, how to litigate, where to litigate in terms of the fora, etc., and how to build charter-based arguments. I will be joined by 5 speakers, as I noted. These speakers, I will start first with Marta Pardavi, who is one of the co-architects of the Starlight program, and she also co-leads, for example, Recharging Advocacy for Rights in Europe. She works through the Hungarian Helsinki Committee on the threats to the rule of law and civic space in Hungary and in the EU, and she has multiple awards for her human rights work as well, and is a member of several boards. Then we'll have Rosalba Striani, acting head of the Fundamental Rights and Free Movement Unit in the European Commission's DG Just, where she leads work on the promotion and enforcement of the EU Charter, among other issues. And she had various other roles within DG Just, including Assistant to Director General, as well as a member of the International Data Flows and Protection Unit. We also have with us Grusha Matevzic, who has been involved with Starlight also from the beginning as an instructor. She is a senior legal officer within the refugee program at Hungarian Helsinki Committee. She worked with the committee since 2009 and coordinates work of the strategic litigation team and various transnational projects. We also have with us Marie-Helene Ludwig, who is a human rights lawyer and senior strategic litigation advisor at ILGA Europe. This is a Brussels-based NGO uniting more than 700 organizations across Europe and Central Asia. She leads impact litigation on LGBT rights before CGU and ECTHR. And previously, she was a member of Paris Bar and also a litigation lawyer for about a decade before she joined ILGA. We were lucky to have her also as one of the Starlight participants in the first cohort of Starlight 2.0. And last but not least, Maria Amor Martin Estebanes, who is a legal and policy officer at EU Agency for Fundamental Rights, where she works in international cooperation and EU Charter Unit. She has DPhil in public international law from the University of Oxford, and she has worked before joining Fundamental Rights Agency as a legal officer for OSCE, also as a consultant for Council of Europe and OSCE High Commissioner for National Minorities, as well as various NGOs. We are very happy to have you with us and hear your thoughts about the Charter and its application and challenges, and as well as the potential. I will start with Marta as somebody that was at the beginning, somebody that conceptualized this project as a co-architect of it. So my first question, Marta, has to do with what was your thinking or a theory of change when you first kind of started thinking about this project, and how do you think the effective capacity building should look like in this area? What makes most difference in terms of preparing lawyers to use the Charter?
Thank you, Nino, and good morning, everybody from Budapest, where the heat wave is still on very much, not only in the temperatures, but also in the political changes, and I'll address some of this later on in these remarks. Nino, when we first thought about Starlight, it was such a long time ago, it seems. It was in Prague, and a discussion was unfolding about how we could really get lawyers to be more aware and more ready to use the tools that we have, because many of the tools that exist in Europe are not used to their full potential, particularly at a time when fundamental rights are coming increasingly under pressure and protection needs are increasing also in tandem. We need basically to become better at using what we have. There's many ideas about how things could be improved at the policy or legal level, but for the time being, we have to also make sure that we use the tools that exist already to their full potential. And so this was the thinking that led us to look at what are the tools that human rights lawyers around Europe, human rights organizations, and also national human rights institutions are using. And just looking at our own organization, the Hungarian Helsinki Committee in Budapest, we try really over the past 16 years, we've really expanded our own toolkit. So using litigation is a very important tool, but beyond that, we've done research, we've done trainings, we've done monitoring, we've done a lot of advocacy at various fora. We have really tried to bring all this together in one comprehensive set of actions seeking impact. But it is quite obvious that litigation has a unique role in all of this. And it is beyond just obtaining justice for individual clients. It is seeking impact. It is about having a strategic change. It is about also at times strengthening the rule of law itself. Because what we realize is that court judgments do a lot more than just resolve the disputes or assist individuals to seek their own justice. They help establish the facts, they clarify legal standards, they can advance legal standards, they can, in fact, reinforce fundamental rights protection. And we see this also in our clients, but we also see this in our discussions, how what we need right now, perhaps in Europe, is to really reinforce standards, to start using tools that exist just because of the varieties of contextual changes. Also in our own work, and I'm sure Grusha will address this, but EU law was not necessarily a go-to tool. Many lawyers who think of human rights cases, who use human rights arguments, still consider and their focus is on the European Convention on Human Rights and on the Strasbourg Court. This is absolutely a fundamental venue, a fundamental tool, a fundamental protection space for fundamental rights in Europe. But we've seen over years how EU is becoming more of a human rights space too, not without its difficulties. And EU law is also evolving and becoming more strong, absolutely, in protecting the idea of fundamental rights, that this is part of our European society. And so this has changed our understanding of the tools. And also, I have to say, the broader context of fundamental rights has compelled us also to think about this. And this is what led us to think about a program where we can bring the Charter closer to legal professionals from around Europe, to help them recognize when EU law can be brought into a case, how this can become, the Charter can become a practical litigation tool before national courts, or where appropriate before the Court of Justice. But one thing that we've also recognized is it's not only a question of legal knowledge, but also of skills. And I think this is where the Starlight program offers perhaps a different set of opportunities for legal professionals. And this is where sometimes the challenge is not only in knowing the law or getting the law to be applied, but also to communicate it, to understand how legal arguments can also be used in a broader context, seeking impact, which I would call advocacy, but also on how we can already use sort of new technologies, open source digital tools, for example, to collect evidence, to preserve evidence, to present evidence to courts. And this is the skills that we've identified as key complementary skills beyond the legal knowledge that Starlight offers. And ultimately, this is the ambition. We want our participants, and I hope that previous participants share this and will attest to this, that they, once they've gone through the Starlight methodology, the training, they will have found new legal knowledge, new legal skills, and of course also a new community, a new network of practitioners who share perhaps the same difficulties, the same obstacles, who share, of course, also the solutions and the inspiration, the commitment to make fundamental rights more of a reality in Europe. Thank you.
Thank you, Marta. Indeed, we will explain and learn more throughout the webinar about various elements. It's an integrated program, and it's not only about making us better lawyers, our participants, but also more skilled to maximize impact on the ground in terms of systemic change. And one question that I wanted to raise, you already mentioned the work that you are doing on the ground in Hungary, and Hungary is now undergoing a process of historic, essentially political transition, and we are watching it also from outside. And I was wondering what you thought, what these developments mean for the rule of law and for charter-based litigation and use of charter at the national level for Hungary. We know that there were some obstacles and barriers in Hungarian judges applying the EU law and the charter, and what do we have a reason to be optimistic now that they will start more systematically using the charter and the EU law, or the structural damage is so deep that it will take time, even if the barriers been absent now, that in terms of the application of the EU law and the Charter?
Yeah, thank you. This is a truly important question, and I remember very much how Adam Bodnar, our colleague from Poland, former human rights lawyer, ombudsman, and then Minister of Justice, now academic, has always emphasized that you need lawyers to take cases to courts. So you need to train the lawyers, but you need also judges who will be able to freely, effectively give effect to European Union law or any other standard. So these are perhaps the two halves of an equation: committed and well-trained lawyers on one hand who can identify the right cases, develop innovative arguments, bring them to courts. They are the ones who perhaps set the legal process in motion, and they are really indispensable. And this is what we focus on in the Starlight program. But there is another half of this equation. And in order to have a full effect of EU law and also of the Charter itself, we need judges, national judges, who are institutionally free, empowered also to act as European judges. This is something that we have, heard from the courts of justice and its president also a lot of times. This is what we've seen also on the ground in Hungary. This has particularly come under pressure in the past 16 years. And so the principal obstacles, perhaps in some member states or other contexts, is not the question of education and building the capacity. This is essential, but also the structural obstacles, particularly as they evolve and are not so easy to fix. So Hungary, in this sense, is perhaps a useful example. It's not the only one, but we've seen how the institutional environment in which judges apply EU law has changed significantly over time. And it's not really a question about whether judges in Hungary understand, the main notions of the primacy of EU law or direct effect of the Charter. Many do. There is a lot of training available. Judges are often very skilled. The question is whether the institutional framework enables them to give full effect to these principles. And there's many examples I could bring from Hungary, but one that is, for example, a legal impediment is something that the European Commission has also identified quite often in the annual rule of law reports. We at the Helsinki Committee also have seen how this is a difficulty that should be addressed. This is a very legalistic, but a very effective impediment to the full effect of EU law. It's called the Uniformity Complaint Procedure. It was introduced in 2020. And basically, its aim sounds entirely legitimate: to ensure that judges have consistency in their jurisprudence. But under the Hungarian system, the published decisions of the Curia, the highest court, are binding on lower courts, and only a special panel of the Curia can effectively release judges from these precedents. And so when the EU Court of Justice holds that every national judge must be able to disapply conflicting national law, including the binding judicial precedent where necessary to ensure the full effectiveness of EU law. This means in the Hungarian context that departing from this precedent first requires the intervention of a higher judicial body. And then the primacy of EU law in effect becomes conditioned on domestic institutional procedures. So this is one example, but for many Hungarian judges, perhaps turning to the EU Court of Justice to ask for interpretation of a national law and its nexus to EU law has come with a degree of unease, and it goes beyond the technical complexities, the technical issues. And this is a question of whether they dare to raise politically sensitive questions, whether these actions, initiatives from judges come with professional consequences. And these are not theoretical examples. I can cite two. These are pretty well known. One is a case where a preliminary reference resulted in disciplinary proceedings in being initiated against the judge making the reference. And this sent an institutional message across Hungarian judges: if you turn to the court, you might get into trouble. Although at the end, it was clear that this action was incompatible with EU law, but the message was loud and clear, although very discreet. Another telling example is a case where a judge obtained a preliminary ruling from the Court of Justice in an asylum case, and then she was denied permanent judicial appointment, left without an effective remedy to challenge her dismissal. So these are, of course, the prime examples of the famous or infamous chilling effect. They illustrate a broader point that the effectiveness of the Charter depends not only on legal doctrine, but also on judicial governance issues. And these are the broad structural challenges that Hungary is now facing. There is a lot to be done. These are structural, these are both questions of governance, internal rules, personnel decisions, and also habitual conduct. So what we're hoping is that this change that we're undergoing in Hungary, and it's only been literally a few weeks, and of course everybody is very impatient, but that these changes will also mean that judges ultimately will feel freer to apply EU law, will be working in an environment where personnel decisions won't be on their mind when they look at a case, when the leadership of the judiciary does not look for technical, sophisticated, extremely savvy ways to circumvent the direct effect of EU law, but rather work in a dialogue with EU law and EU courts. And this requires quite a fundamental shift, I think, in Hungarian judicial leadership. There's a lot of discussion about this ongoing. I don't want to go into it now, but I think there will be important developments on this front. But also, of course, it requires space for lawyers and judges to interact. This happens firstly in the courtroom, but I think joint trainings, joint capacity building events, opportunities to see the other as a partner in learning will also potentially help bridge this gap. And I hope that programs and partners will be available and ready to address this part too in the coming years. Thank you.
Thank you very much for this optimistic, forward-looking point that perhaps, and also highlighting the significance of trainings and other efforts that are enabled by, including Starlight, are enabled by the Commission. Now I'm turning to Rosalba Striani with the questions regarding the Commission's work and plans. We saw that the midterm review of the Charter strategy was published last year, and we saw that despite there's some progress, obviously, and we see it, but at the same time, there's still challenges in terms of effective use of the Charter, especially, and including strategic litigation. It would be great to hear from you what the Commission has been doing and is planning to do to address these remaining challenges in terms of supporting civil society, national human rights institutions, and other actors that are that can and should be applying the Charter of Fundamental Rights. The floor is yours.
Thank you very much, Nino, and good morning, everyone. It's a real pleasure to be with you today. It's my first time. I see already from the first intervention that this webinar is very promising in terms of the richness of the discussion. I also would like to congratulate you for the successful training on the first cohort. So, as it has already been said, the fact that we are all here today shows how important is strategic litigation in the framework of making the Charter becoming a reality. Empowering lawyers, civil society, and national human rights institutions to use more effectively the Charter is a common objective. And to reply to your question, indeed, the Commission has adopted its annual report in December on the application of the Charter in the EU, which takes stock of the implementation of 2020 and 2030 Charter strategy within the past 5 years. To prepare this report, the Commission has conducted a broad consultation with key stakeholders group, including justice practitioners, national human rights institutions, civil society. And this consultation has been very helpful to identify both gaps and achievement in the implementation of the strategy. The 2025 Charter report showed that most of the policy commitment of the Charter have been fulfilled. At the same time, also it pointed at some significant gaps. And one of those gaps has definitely been identified in the knowledge gap. Overall, the consultation has shown that while the public, including the member states administration or legal practitioners, often lack sufficient knowledge or awareness of the Charter rights and remedies. So availability of training on the charters remain low, and it is crucial to be increased. So this is particularly important in the context of justice practitioners who apply the Charter in court and have a unique role in ensuring the applicability of fundamental rights. Providing information and training on the Charter is a key importance to unlock the Charter's full potential. In fact, the Commission has also themselves, as a deliverable of the Charter, just launched an open online training course on the Charter, financed by the European Commission and prepared by an academic consortium led by the University of Leuven. The course, which walks you through article by article and in the assessing of the Charter, is free of charge and available on the EU Academy platform. Another significant challenge identified by the midterm review, but also before by the Charter report on the topic of funding, is the lack of sufficient resource for civil society and national human rights institution, in general, equality body, the entire ecosystem supporting the Charter. This has been shown by all this report and also through the consultation of the 2026 Charter report, which focused specifically on national human rights body and stressed the shrinking of the civil space and hostile environment that these actors are facing in terms of funding in the broader sense. So the Commission will further reflect on the role and the challenges of fundamental rights body in the 2026 Charter report to shed light on this institution and to stress the important roles that these institutions have in supporting the implementation of the Charter. Moreover, I would like also to mention that in 2025, November, the Commission adopted the first ever EU civil society strategy to engage with, to protect and to support the civil society, setting up a framework to create a dialogue with the civil society and to identify also the threat that civil society is facing. So, in fact, the strategy acknowledged the challenges that civil society is facing across Europe, and recognizing that many experience an overall shrinking space and attacks in relation to their work. Also here, the strategic litigation can play an important role in protecting civic space by helping to safeguarding civil society who are increasingly facing threat and challenging as a result of their work. I cannot be complete if I would not mention the funding aspect to respond to these challenges. The Commission is committed to support capacity building on the Charter through the SERVE program, which in 2026 runs in two strands: the raising awareness of and building capacity for the Charter, and promoting and enabling the civic space. The budget of 2026 call has been significantly increased across both strands. And as part of the civic space strand, the call will also focus on building capacity of civil society actors, on enforcement, and also on strategic litigation on fundamental rights, including in response to against strategic lawsuit against public participation slabs. So under previous charter calls, the aim of supporting project in the area of strategic litigation is to improve the capacity and ability of civil society, NHRIs, and equality bodies, as well as legal professional, practitioner, ombudsman institution, and other human rights defender to develop and implement litigation strategy and strategic litigation approaches in the area of fundamental rights. So Starlight is a great example of this. So I think I've given more or less an overall overview of what the Commission intends to do and what were the main challenge that the Commission tried to address, and we will continue to do this in partnership with all of you. So thank you very much.
Thank you very much on this. We are indeed find it very important that there are such continuing opportunities in response to the continuing need for knowledge, addressing the knowledge gap in lawyers and other parts of the ecosystem. The second question I wanted to ask you is in terms of looking into the future. We had strategy that was designed in 2020, charter strategy, and the political environment is changing. So how do you see this developing to address the challenges, and how do you see in the future, ideally, that what type of use of the charter would you see kind of in the ideal scenario for the future?
Yeah. Well, for the future, first of all, we have a strategy that we have to implement with a number of deliverables. The strategy looks taking what we have done, so take stocks of the past, but also looks toward the future, what to be done in the coming years until 2030. And in this respect, I would say that it really looks broadly at common efforts that can be done both when it comes to raise awareness on the charter and to support training and capacity building. But also the Commission will continue its monitoring and will not shy away to start infringement when needed. I think one important tool is also the Charter Hack, the horizontal enabling condition that in the proposal of the multi-annual financial framework will become structural. So the compliance with funding in its implementation will become, in my view, even more important. I think we should help the member states to understand how to get compliance of this monitoring and in the implementation of the charter. And in this respect, both the training and the awareness raising is fundamental. So there are many tools that complement each other. I think also that the future, when we look at the future, we have to look at a co-shared responsibility for the implementation of the charter. We have spoken about lawyers, judges, the Commission, the member states, the national human rights institutions, your projects. So we have, I think, real and important tools. And the previous speaker indeed has stressed the importance how to make the best use of these tools, and this is exactly what the Commission is looking at to ensure the effectiveness. Of course, judges are helping us a lot. The European Court of Justice is helping us a lot, as well as the court in Strasbourg. So feeding the litigation is crucial for ensuring that in whatever political context we are, the court remain stable in the principle. And of course, in this context, also the deliverable that we intend to achieve under the strategy for civil society are crucial for us. Because we'll ensure to protect, promote, and engage with one of the main actors, which bring the voice that they are the holders of the rights, the fundamental rights. So I think this is also an important element that the Commission will be very much willing to continue protecting in the coming years. So I would say that it's a bit the combination of all the soft measure that we have, the funding measure that we have, the enforcement measure that we have. We know how important is the respect of the values, and as our president reminds in all her speeches, that the Europe is found on values, and the interlink between, as already been said, between fundamental rights, rule of law, is stronger and stronger. And I would say also with our democracy. So protecting fundamental rights is not only protecting individuals, but it is protecting also our democracy and the credibility of Europe vis-a-vis also international partners. So I would say that I hope with these words I have conveyed all the commitment that the Commission has to protect fundamental rights. And I would like to thank you again, because I really believe in the strategic litigation as one important tool to feed those objectives. Thank you.
Thank you so much for being with us and for sharing your thoughts, and also Commission's approach, multi-pronged approach, to also continue supporting various actors in application of the Charter for better strategic litigation efforts. Now I will turn to our next speaker, that is Grusha Matevzic, who is one of the co-leads of one of our thematic areas in the program, asylum and migration. Grusha, you have been very vocal also in the past, saying about the potential of the Charter and how it's really an important and powerful tool which we don't have a choice not to use. Really, for this new cohort also, maybe you could tell us about how you see the potential and the obstacles as a practitioner in this area, like in looking back, but also looking forward at future litigation efforts.
Thank you, Nina. Hello, everyone. Yes, at the Hungarian Helsinki Committee, we definitely refer to the Charter as much as we can in our litigation practice. We have to, because where domestic litigation legislation and practice is breaching fundamental rights of asylum seekers and migrants, then the EU law is our biggest ally. And we have been litigating several Charter provisions, such as Article 1 on the right to dignity when psychological testing was used in LGBTI asylum cases, or Article 4 on prohibition of inhuman and degrading treatment regarding reception and detention conditions and in cases of refoulement, Article 6 on the right to liberty when asylum seekers and migrants were unlawfully detained, Then Article 7 on the right to family life in withdrawal of residence permits and expulsion cases, as well as Article 18 on the access to asylum, and of course Article 47 on the right to an effective remedy in national security cases, in cases where asylum authority would not respect the court decisions, in cases of non-existence of domestic remedy, and so on. So just to give some examples, one of the main obstacles, which was already mentioned several times, has been the reluctance of the judges to refer a preliminary reference or to suspend a case due to a pending preliminary reference closely connected to the matter we litigate. A lot of effort, time, number of cases, and patience were needed to finally achieve a breakthrough. Another obstacle, which I emphasize all the time, is the non-implementation of the CGU judgments. And what I gave as an example at the last year's Starlight launch is unfortunately still fully true. There are no changes after the so-called pushback judgment, where the CGU imposed financial penalties in high amount for each day of non-implementation. So this is still, the non-implementation of CU judgments is still a big problem. Hungary specific is also a so-called uniformity procedure, which Marta already talked about. So I will only add that luckily we already managed to get a preliminary reference referred questioning the compatibility of such uniformity procedure with the EU law, and the judgment will be announced on 16th of July. So if you are interested, I invite you to check the Bukla case, C26/25. It's also a relevant case in case you are dealing with access to classified data in national security cases. I would also like to add that a follow-up on implementation of preliminary reference judgments, so cases that were not the result of infringement procedures started by the Commission. There, I am not aware of Commission bringing such a case back to CGU for non-implementation, and therefore it is on us litigators and the advocacy staff to push for implementation, which requires a lot of resources. So I see that I would think there could be some improvements also on the institutional level. And finally, as for the support, I believe in training. So Starlight-like initiatives definitely empower the practitioners. I would also like to emphasize the new element of the Starlight, so-called mentoring. At Hungarian Helsinki Committee, we litigated over 100 ECHR and over a dozen CGU cases in the field of asylum and migration. And we are now very happy to share our knowledge and provide individually tailored legal and advocacy support to selected participants in their actual cases. So this new element, I think it's quite a useful one. And finally, what I also always say is that what is really needed is funding. It's extremely hard to get funding for litigation. I would wish for more financial opportunities where we could apply to as litigators, and of course a better functioning state legal aid system.
Thank you so much, Grusha, for highlighting some of the things that we can be alert about. I absolutely share your concern also in terms of the preliminary reference procedure and the implementation of those. We are trying to, at DRI, together with the European Implementation Network, to really collect this data. But it is quite a kind of a challenging aspect. We found that most judgments that are not implemented are charter-related ones, and most of them are Article 47 related rulings in our practice across the EU, as well as data protection related rulings. But definitely that's something when we see a systemic reluctance of authorities to implement those, I think some level of action is probably called for. So I will ask you a question about the next question about the new pact on asylum and migration. I really wonder what are the prospects that you see? Does the pact really narrow space for charter-based challenges, which we hear sometimes, or does it maybe open some new angles? And how do you see the litigation strategies working out under this new pact?
Yes, from the Hungarian perspective, we are facing a difficult situation because the government refuses to implement the pact, so absolutely nothing was done in this field. At the same time, the pact is already in force, the regulations are directly applicable, so when it comes to litigation, you have to rely on the pact. And I know pact can be problematic from the fundamental rights perspective, but from the perspective of Hungary, we think it is still better than what we have now. So where there is no access to asylum and pushbacks are legalized. So our position is not to argue against the pact, but to apply the pact and to ensure access to asylum. But outside of the Hungarian context, I would say that there will probably be big challenges regarding, for example, de facto detention situations and conditions, procedural safeguards in border procedures, vulnerability assessment, collective or nationality-based reasoning instead of individual assessment, arbitrariness in invoking national security reasons, the effectiveness of independent monitoring mechanisms, and so on, just to name a few. As for Article 47, there are definitely concerns regarding a gap between an existence of formal remedy and the effectiveness of such a remedy. Problems may arise where legal aid is unavailable in practice, where lawyers and NGOs have restricted access to border facilities or detention facilities, where applicants cannot obtain evidence in time, when suspensive effect is not automatic and the person risks removal before meaningful review, or where the court's review will be focused only on legality in the abstract without full factual scrutiny, how to challenge the findings on vulnerability, and so on. So quite a lot of challenges ahead. As for the litigation, yes, there will be a shift because regulations are directly applicable. So preliminary references will not be so much asking whether national legislation is compatible with the EU regulation, but it will be more about the actual implementation in the use of practice. So it will be more about you would have to produce a lot of evidence, and it will be about proportionality, about procedural guarantees, about individual assessment, and the practical effectiveness of the remedies. So the questions asked will be more in the sense if the implementation of the pact in these factual circumstances disproportionately restricts charter rights and make the remedy ineffective in practice. That's what I think. I have to add here that it's not part of the pact, but it's coming up. So, and since this Starlight asylum and migration stream is also not just about asylum, but migration rights as well. So I'm quite sad to see the proposed return regulation. Since the way it reads now, there are quite some incompatibilities, in my view, with the existing ECHR and CGU case law, a case law to which Hungarian Helsinki Committee, as well as other asylum and migration lawyers, contributed significantly. And now this new legal instrument tries to go against our work and litigation achievements. So for me, this is quite sad to see. But to conclude, I hope that although I like litigation, but I still hope that before litigating there will be a possibility for a dialogue with the government to find a solution together, how to best apply the pact in charter compliant manner.
Thank you so much. It was kind of forecasting of the complexity of what we will be discussing in the Starlight program in these areas. So I'm really looking forward to really see how some of these challenging issues will be addressed and by us as a community together with participants as well. And thank you so much, Agrusha, for your reflections. And I think we'll continue our discussions on these topics. And I want to now turn to our next speaker, Marie, and switch thematic focus a little bit to LGBTI rights. As this is your area of expertise, I wonder what broader tendencies do you see in the Charter application in your area? And we see that there have been quite a few cases recently on these topics. So what do you see in terms of the Charter use?
Thank you, Nino, for the question and for inviting me today. Good morning, everyone. It's a real pleasure to be with you today and to see again the Starlight team. So as you mentioned, we provide support at ILGA Europe. We provide support to applicants and organizations involved in CJEU cases concerning the fundamental rights of LGBTI people. And what we have seen is that the Charter has now become a central instrument in this area. The court, in its judgments, increasingly reasons through fundamental rights considerations in those cases. So now we really encourage lawyers working on this topic to consider litigation before the CJEU when there is a link, of course, with EU law and not just the Strasbourg court. And if I focus on just the past 2 years, the court rendered several judgments in preliminary ruling proceedings since 2024 that are really important and that I can mention briefly, that are largely based on the Charter, notably Article 3, so the right to the integrity of the person, Article 7, the right to private and family life, and Article 21, the prohibition of discrimination on grounds of sexual orientation. A majority of those cases were based on free movement rights. So, for instance, in the Mirin judgment, the court found the violation of the right to free movement of a trans person who was refused by Romania the recognition of his new name and gender marker acquired in another EU member state. So that was a violation of his right to free movement, but also the court found a violation of his right to private life. And there is a second case, the Shipova case, also concerning a trans person who is Bulgarian and who is residing in Italy and who is refused legal gender recognition by Bulgaria. And this was again a violation of EU free movement law, plus a violation of Article 7 of the Charter. And again, another very important judgment of last year, the Trojan judgment, also in which the court also recognized the violation of free movement rights of a same-sex couple who got married in Germany, and Poland was refusing to recognize this marriage just because they were a same-sex couple. So here the court found a violation of their right to free movement and added a very strong reasoning based on Article 21 of the Charter. And the court found, even for the first time, that this provision in Article 21 is a general principle of EU law, the prohibition of discrimination based on sexual orientation. And this allowed in the judgment, this allowed the court to specifically target the discriminatory effects of Polish legislation that was not recognizing same-sex marriage. I can quickly mention also a case based on GDPR, in which the court found a violation of the GDPR rights of a trans refugee in Hungary. And the court also found a violation of Articles 3 and 7 of the Charter in that case, the Deldic case. And finally, I want to quickly mention the Commission versus Hungary EU values case. That is a really important case. It received a lot of attention and commentaries because the court found a violation of EU values of Article 2 of the treaty. But I also wanted to highlight that the court also found a violation of 5 Charter provisions, including an independent violation of the right to human dignity. So in our area, and to reflect on what Marta was saying at the beginning, we really see the CJEU becoming a human rights court, just as important as the Strasbourg one in this area.
This is great to hear, and it shows that its use of the charter is then less of an issue and more problem is the implementation of those charter-related rulings. Is it the right sense in your perspective, in your view?
Yes, I can only share what Grusha just mentioned. In addition to very important challenges related to funding, there is barely no funding on litigation costs, issues that concerning the referral of preliminary ruling questions to the CJEU. One of the systemic issue that we face is concerns securing effective implementation of judgments. So this is linked to the fact that there is really no supervision mechanism to supervise the implementation of CJEU judgments. And this is really a systemic issue in LGBTI rights cases. So for instance, there are judgments rendered in 2018 in the Common case, in 2021 in the Pancharevo case, that are still not implemented by Romania and Bulgaria, respectively. Or we have judgments that are interpreted in a very narrow way by domestic authorities. So for instance, the Delvic case in Hungary, and that will require follow-up litigation at the domestic level to actually have the expected effect. I can still end on a positive note concerning some recent judgments, as after a very long process that started in 2021, judgment rendered by the CJEU in 2024. This year, the applicant in the Mirin case obtained his new documents in Romania after his legal gender recognition. So Romania did implement the Mirin ruling concerning the applicants. And in Poland also, after the Trojan ruling that I mentioned on same-sex marriage, Poland is now recognizing same-sex marriages concluded abroad. So it's in the process of changing its administrative process. So we also have positive examples, but overall we are really monitoring the implementation of judgments. The Commission versus Hungary judgment will be an important judgment to monitor. We are expecting Hungary to see how Hungary will comply. And on that topic, we are working with the Commission and asking the Commission to monitor the implementation of all those judgments and to open infringement procedures when needed and when states fail to comply.
Mm-hmm. Thank you so much. Just a short reminder, because I have one more question and we have another speaker on the line. I want to remind our audience that if you have any questions towards any of our speakers, especially Rosalba, she might have to leave at one point, please drop them here in the next couple of minutes. This is your chance. Also, if you find our webinar interesting, please fill into the EU survey that my colleague shared. That all the necessary information is in the chat. If you have a chance, please fill in. Thank you. And then I wanted to kind of the final question, Marie, in terms of your experience of building charter-based arguments. So what were the learnings from your past experience, and maybe you play into maybe Starlight experience also in terms of how it was with you in terms of structuring and learning about charter-based argumentation?
Yes, so what's important for lawyers to have in mind is that the charter applies only when member states are acting within the scope of EU law. So that's the main challenge. It's to find a legal basis, an EU legal basis beyond the charter. That would have to be invoked, so such as the ones I mentioned before: EU free movement rights, equality directives, the GDPR. So, and then litigants have to explain how and why the charter informs the interpretation of those of EU legislation, basically. So the charter is really here to strengthen or highlight fundamental rights issues, but to strengthen other arguments. And another important aspect is that it is important to refer, in our area at least, it was important to refer to European Court of Human Rights case law when building charter arguments, because both the charter and the convention contain corresponding rights. And we see that the CGEU refers a lot to ECTHR case law in our area. And so here I can share a bit how useful the STARLIGHT program is in this respect, in learning how to structure charter-based arguments. So the two important aspects, at least the two aspects I appreciated the most in the training, were first the knowledge and skills aspects. On one side, where you are able to attend thematic modules on specific topics. And what's useful is that all the modules are based on examples of CGEU cases. There are also modules on litigation where you learn how to apply the charter, how the CGEU approaches those cases, and all the courses have practical exercises where, as a participant, you can really practice on real cases and learn how to structure arguments based on the charter. And the second aspect I wanted to mention on the program is really the peer learning aspect. So you really have a chance to spend a couple of days with other lawyers. You have an opportunity to exchange on current cases. And for instance, I met several lawyers who are working on the same matters, but for instance, from a different angle, from a domestic law perspective, or from a digital rights perspective, for instance. So we had really interesting exchanges. So I would really encourage lawyers from our membership and network to apply to the next with the next cohort.
Thank you so much, Marie, and for your reflections, for your positive kind of identification of trends, which shows
Yes.
that really charter argumentation works. But at the same time, I think there's a common warning across our panel, also with Grusha, from practitioners' perspective, that it's only half of the way when we secure the charter-related rulings, and bigger work is on the implementation side, which makes our skills workshop perhaps also quite useful, because that is something that lawyers are not usually trained to do. Advocacy, communication, etc. So with this, we will now turn to our last speaker for the panel, Maria Amor, who will share with us some of the resources that Fundamental Rights Agency has for practitioners, because this may be useful in the work as well. Please, the floor is yours. Please share the screen and
Thank you very much, Nino, for the opportunity to contribute to this webinar. I appreciate it. I'm now sharing, I hope, my screen. Please let me know whether you can see it.
We do, yes.
Great. I will now put it on presentation format. 1 second, because I have a big screen here. So it's to get to it. Okay. You can see it now, no?
Yes, we do. We do.
Fantastic. Very good. Okay. So, well, first I would like to introduce you a bit the work of the EU Agency for Fundamental Rights around the Charter. The agency provides assistance and expertise to the EU institutions and member states when they apply EU law, and of course, in the field of human rights. Yeah, and of course, the Charter is a key instrument for us. The agency, also known as FRA, that's the acronym, contributes to the implementation of the European Commission's Charter strategy and supports the EU institutions and member states in delivering their obligations under the Charter by providing data, analysis, advice, guidance, training, and e-learning for practitioners. It also promotes awareness about the Charter more generally. So, annually, the EU Agency for Fundamental Rights produces what we call the Fundamental Rights Report, which provides an overview of the situation in the EU of fundamental rights, also in the member states, but also the policies and the laws of the EU at the higher level, at the institutions and so on. From those annual reports, we have already started to draw some conclusions with regard to the application of the Charter. So I will start with these general ones. So from the perspective of the national courts, there is a positive trend, both in quantity as well as in the quality of references to the Charter. However, still most references remain superficial, and often in the decisions of the courts, there is really not an argumentation around Article 51, that is on the applicability of the Charter, and because we are under EU law. Yeah, so normally the court decisions don't elaborate on this aspect. There is also, we have noticed a very high importance, and this was already mentioned, on requests for preliminary rulings from the Court of Justice of the European Union to make the Charter better known by the national courts and more used. But also another key aspect we have realized is the importance of the constitutional standing of the Charter, because in some member states, the Charter has acquired a semi-constitutional standing just because of decisions of the national courts, the Supreme or Constitutional Court. Yeah, this has been the case in Austria and in Germany with regard to the constitutional courts in particular. These are the more clear cases of member states. Then, from the perspective of member states legislators, which of course is the key pillar on which the decision then will be taken, there are very few references to the Charter during the legislative process, and procedures mostly do not explicitly call for checks on the Charter, including on impact assessment proceedings. Yeah, so there is not specific guidance that require Charter checks when legislation is being drafted. So, and then more references are therefore superficial and sometimes even inconsistent. From the perspective of the governments, we have seen there is hardly any government policies in place to promote the Charter, and internal in the internal practice of the administration, there is not much coordination and cooperation around the Charter, and also interministerial cooperation is largely missing. Only there are a few exceptions that we mention in our reports. And also what is interesting, there are also some interesting cases of cooperation around the Charter between the regional and local governments as well, which we think is also worth pinpointing as good practices. And then, well, what has been, we consider an important breakthrough to facilitate the Charter implementation has been the development of the figure of the Charter focal points at national level under the Charter strategy, which, well, as you have known, well, Rosalba referred to it, was recently reviewed in December. So this has been really an EU opening to facilitate, hopefully, the coordination of work around the Charter in the EU member states. So when it comes to the court, and this is and the use by the member states. Yeah, this is what you can see on the screen is a pie, which is a very rough, almost prepared now for this presentation, updated. Yeah, and so it's not like an official finding, but I hope it gives you an overall idea of what the tendency has been we have identified over the last year. Yeah, so in 10 member states, there has been an increased application of the Charter. One member state, the increased use has really been seen on the side of litigants. And in 4 member states, this has been an increase, but not by the lower courts, because normally it's the higher courts which tend more to refer to the Charter. Whereas in 12 member states, the references have remained limited more or less as they were before. What are factors that influence the use of the Charter? First of all, very important is the degree of international integration of the Charter into the legal system. And as I already mentioned, the stance of the constitutional courts. And here I will give you some examples. In Latvia, to bring a claim for a breach of an international instrument generally, the applicants first need to substantiate whether this instrument provides broader protection. And due to this high level of exigence, yeah, there have been no proceedings on compliance of Latvian legal provisions instituted so far. Yeah. In Bulgaria, 2021, in 2021, there was a review of the procedure rules, and the referrals to the Constitutional Court need to include an assessment of EU law. This has been, of course, very positive in the sense that it has increased the engagement of the courts with the Charter, but it has also resulted in many dismissals of cases because of not complying with this. And it has also resulted on the positive side on increased number of requests for preliminary rulings. In Luxembourg, before addressing the Constitutional Court, the lower court needs to carry out an EU compliance check of the norm. So this also, of course, supports the application of the Charter and the knowledge about the Charter at national level. As I already mentioned, the very interesting cases are those of Austria and Germany. In Austria, the Constitutional Court recognized Charter rights similar in wording and determination to the rights in the Constitution as constitutionally guaranteed in 2012 in a leading decision. And in Germany, the Charter is used as a constitutional benchmark in areas of law which are fully harmonized under EU law by the EU legislature. So this semi-constitutional status contributes to the overall prominence of the Charter within the national legal system. With regard to the Charter before national courts and to have an overall picture, the most leading policy areas where the Charter is most used is, as it was mentioned here, asylum and migration, also criminal law and personal data protection. And then with regard to the Charter rights which are most used, let's say I put them leading, of course, in quotations, are Article 47 on effective remedy and fair trial, Article 20 on equality before the law, 21 on non-discrimination, 7 on respect for private and family life, 8 on protection of personal data, and 41 on the right to good administration, which is also a very interesting, I think, development. With regard to the means of application, what facilitates the Charter application and the way it has been used, yeah. First of all, it has been used to give direct access to rights. It has also served to interpret national and EU law, but also, of course, to check the legality of national law versus EU law. And I will now give you some examples of the last year, which could be interesting for you to get a concrete perception. With regard to direct violations of the Charter rights, the Federal Constitutional Court of Germany overruled the Court of Appeal in a case concerning the European arrest warrant, and this concerned the extradition of a non-binary defendant to Hungary. The question, of course, was whether the defendant rights were sufficiently guaranteed, and the court found that no sufficient information and assurances were provided, and this actually entailed, or the court found, a violation of Article 4 of the Charter, which prohibits torture and degrading treatment or punishment. Sorry, because I see now a typo here, which I will correct later, maybe, because otherwise I just lost 1 second. Okay, direct violation of the Charter. Yeah, here. So let's go to the next case. In this case, it's an example of direct application of the Charter, again, in a case of the Supreme Court of Latvia, which looked into the legal relationship between companies and board members. This case concerned a person who requested, it was a member of a board, actually, who requested compensation for untaken paid annual leave. And of course, the big question is whether members of boards and companies would be considered as workers, yeah? and therefore benefit from paid annual leave. So in this case, the national commercial law was silent about the topic. And interestingly, the Supreme Court of Latvia referred to the EU autonomous concept of worker, which in this case was seen as to include members of boards of companies. And the court actually applied by direct effect Article 31 of the Charter with regard to fair and just working conditions, in addition to Article 7 of the Working Time Directive. Another important way in which the Charter is used, of course, is the legality of EU and national law, to check on them. And in this case, we refer to a case of the High Administrative Court of France, the Conseil d'État, which mentioned, and the case concerned the removal or blocking of access to terrorist content online. So the applicant actually, argued on basis of privacy and the personal data protection and many other aspects, and of course freedom of expression as well, to challenge both the EU regulation and the decree which was applying the regulation at national level. And the court, after conducting a general analysis of the content, found that there had been a violation of those articles in conjunction with Article 10 of the European Convention on Human Rights, Article 7, 8, 11, and 52 of the Charter in conjunction with the European Convention, and also declare that the absence of a suspensive effect of remedy is not contrary to Article 47. And I want to tell you that, in this case, the court found that the decree itself and the regulation were not in violation of the Charter articles, even if those articles had been raised by the applicant. I'm sorry if I first may have led you to confusion. There was actually non-recognition that there was a violation in this case.
Dear Maria Amor,
Yes.
I apologize. We probably, since we are a bit tight with time, maybe
Yes.
a couple of minutes, a minute or so to wrap up.
Yes.
I think I would ask you, it's very rich presentation. I would ask you maybe perhaps if you could share it with us, and we'll attach it to the recording when we share it also with the participants and other actors through our outreach campaign. Thank you.
Yes. So there are also another few cases I refer to, but I want to then, as a last, in various aspects, also with the interpretation of national and EU law, but I wanted to bring to your attention finally, first of all, the increasing trend for having more preliminary rulings coming from the EU member states as a whole. And here you have the statistics which are published yearly in our Fundamental Rights Report, annual report I mentioned earlier. But also I wanted to show you the tools we have that can be used by practitioners in their practice on the Charter. So we have the so-called Charterpedia, which is a case law database. It contains, first of all, the Charter articles, etc., and then a case law database. Then also we have a case law database in particular, which includes EU, European Court of Human Rights, and member states cases that could also be drawn on to check on the doctrine existing at the moment. We also have a Charter application for the telephone, but this only so far includes basically the Charter, but not the case law and all the rest. Then also we have produced a handbook, which actually is basically around the applicability of the Charter, which was mentioned earlier as an issue of difficult for lawyers to identify, and it contains a checklist to help lawyers to check whether we are under EU law and the Charter applies, basically, which is available in all EU languages and Ukrainian as well. Then we also have charter e-learning courses where there is an online platform which allows you to basically that guidance I mentioned earlier is applied online, so you can get a step-by-step analysis of whether a case falls under Article 51 of the Charter. It's applicable, the Charter is applicable. Then it also provides examples showing the fields in which the Charter is applied. We also have Charter videos and Charter case studies for also for group learning on the Charter, and a trainer's area and a trainer's manual. Yeah. And I actually encourage you, of course, to register for those learning materials, which again are available in all EU languages except EU official languages except Maltese and Gaelic. I mentioned already the manual. We also produce some brief country sheets, and we are also hoping now to starting to produce some charter fact sheets regarding particular articles, and for example, on the protection of the rights of the child, we are now preparing one. And finally, I would like to mention also how we have the help course of the Council of Europe provides training on the European Convention and the Charter interplay. FRA has contributed to the development of that course. And last but not least, Rosalba had mentioned to the recently published European Commission's courses on the EU Charter, and she had referred to them, and here you can find the link. Thank you very much.
Thank you so much.
I forgot one more thing, sorry, is to convoke you, whoever is interested, because in November, actually will be on 23rd, 24th November, we will have the next EU Charter Exchange, which is organized by the European Commission and FRA, and is a forum for discussion among legal professionals. There are presentations, but there are also possibilities for consultation and discussion. So I hope you will be able to
Great. Thank you so much for your very comprehensive presentation. We're very happy to have you. Maybe you stop sharing the screen. In the meantime, I want to thank our experts today for their very rich contributions. I think this is very useful because then we can make this recording available for a broader audience as well, those who were not able to attend. And now I would like to give floor to our colleague at Hertie School, Georgia, for the presentation of the program. We'll go through various aspects of it and the application process as well in the remaining 10-15 minutes. 10 or so, I guess, because our discussion maybe lasted a little longer. Georgia, please share your screen and tell us a little bit about the program, and of course we remain available for any questions you might have.
Yes, absolutely. Thank you so much, Nino, and thank you for our panelists for this really insightful exchange so far. So my name is Georgia. I am a project coordinator at the Hertie School here in Berlin, and I will be giving you a bit more of an overview of our STARLIGHT program, so including basically what STARLIGHT is, what our participants can expect from our program, its timeline, its eligibility criteria, and also, of course, how to apply. I'm going to try to be mindful of the time, but maybe first of all to give you I can't change the slides. Now, I think it's working. First of all, to give you a bit of an overview of what is STARLIGHT. STARLIGHT is a 12-month capacity building program that is designed, as you know, for legal practitioners working across the EU. Our program focuses on developing skills and knowledge needed to apply the Charter of Fundamental Rights in strategic litigation. Our participants will be taking part in a variety of formats throughout our program. We're going to have 2 in-person workshops here in Berlin. We will have online legal clinics, as already mentioned throughout, will be collaborative legal casework within our participant groups. We will have networking opportunities and also, as Gruja mentioned, mentoring opportunities for some of our selected participants. So in this context, the key objective that our program has is first the objective of applying the Charter of Fundamental Rights and other EU laws within the thematic areas of rule of law and democracy, as well as our second stream, asylum and migration, as well as acquiring the crucial skills to engage in strategic litigation at the EU level and thereby promoting systemic and social change in your respective countries. So in terms of the timeline, this is what your Starlight journey could look like with us. Applications will open today and they will remain open for a while. We wanted to give you some time in your summer break to prepare your application documents. The portal will remain open until September 20th. Then we will have our review of the applications. Our steering committee will go through your documents and successful candidates will be notified in early October, likely within the first week. And then the most important part is the first event, the first in-person workshop, which will be the thematic workshop in Berlin in the second week of November, most likely between the 9th until the 11th. And it will then be followed by group work in the legal clinics until we meet again in person for our second workshop in Berlin, which will be the skills workshop in the first week of March, with the exact dates to be confirmed. So again, then after this second in-person workshops, our participants will continue working together in the online legal clinics, and we will also have our mentorship period for some of our selected individuals. So in terms of eligibility, our ideal applicants should hold a law degree and have at least 2 years of relevant professional experience. The program, as you've already heard, is aimed at a range of legal professionals, which means you may be a lawyer working in a law firm or as a solo practitioner with experience in fundamental rights or rule of law cases. You may be legal staff working within an NGO and involved in developing or coordinating litigation strategies. Furthermore, we welcome practitioners from legal clinics working on fundamental rights cases, as well as legal professionals from national human rights institutions that are involved in litigations, creating briefs, or third-party interventions. Important is hereby that our applicants have to be practicing law within one of the member states of the European Union. So how to apply? Applications will be submitted through the Hertie Schools application platform. You can access this platform via Google search, the Hertie School website, DRI, our Starlight overview, or simply by scanning the QR codes here in this webinar. So after creating a profile on our application portal, you can select Starlight under the executive education programs and then complete the form with your data. I will briefly go through what we expect as part of the application process. We will be asking you to provide several pieces of information. So of course, your basic information, current CV, and a motivational statement that we ask you to upload in English and as a PDF document. We will further be asking you for a link to a short video of really approximately 90 seconds. In this video, we would like to ask you to briefly introduce yourself, explain why you would like to participate in Starlight, and important is that you make this video accessible to us by sharing a link to a shared platform such as Google Drive or a private YouTube video, but please make sure that we do actually have access. You will then also be asked to provide a description of your litigation experience and provide 1 or 2 example cases that you would like to explore during the legal clinics. And when discussing these example cases, please keep in mind that we would like to ask you to align these cases with the thematic area that interests you most. As we already mentioned throughout, there you can also select this preference for the thematic stream, either being the rule of law and democracy track, which will be focusing on examining topics such as freedom of association, civic space, the juridical independence under the EU laws, or the asylum and migration track, focusing, for example, on the application of EU law, fair trial, effective remedy rights in the migration and asylum contexts. And in addition, we will also be asking you to indicate a ranking of your preference for our second skills workshop, which will happen in March. We will be offering 3 different areas, as Marta also mentioned earlier, being the documentation and evidence stream, the legal advocacy track, and legal communications and PR. So this very effectively, sorry, I tried to rush through a bit, brings us to the end of the program overview. I hope that this briefing has given you a better understanding of our program and also the application process. We will be opening this into a Q&A for the last few minutes for those that can stay online. But of course, we're always happy to answer any questions. You can reach out to starlight@democracy-reporting.org, as well as, of course, us at the Hertie School Executive Education Department as well. And we're very excited to hear any questions, should there already be some from the audience.
Thank you, Georgia, very much. Just while people are thinking about questions, I want to highlight that we have posted in the chat the link to the call for applications, which also outlines in greater detail, especially what particular streams and workshops entail in terms of the substance and methods of teaching, etc. So you will have to choose one of the 2 thematic streams, asylum and migration or rule of law, civic space and democracy, and one of the 3 skills workshops, documentation and evidence, the advocacy and communications. And please take a look at the timeline, especially because you would need, it's absolutely critical to be in person available for the workshops in Berlin, because missing those means that you won't be able to continue with the program, be part of the program. Other elements are online, so there's more flexibility there, but the 2 workshops in November and March are mandatory for in-person participation. So all the other details are there. The scholarships, one element that's worth mentioning is that you would not have to pay as participants a fee for the course, and also your accommodation costs in Berlin will be covered as well. But the travel costs have to be covered by participants themselves. There's a lot of details. We'll let a couple more minutes for questions, but if there are no questions, we are of course available. The call for applications opens now, and you can apply anytime throughout summer, but the latest you can apply is 20th of September. And we remain really available for any questions. You can send out questions regarding eligibility or other aspects of application, or if you have any issues with the portal or anything along those lines, we are here to address your questions and facilitate and make the process as smooth as possible. I don't see any of the questions. Typically, we don't have much because I'm hoping that means that we are explaining things very clearly. But we might consider at a later stage also doing an information session if necessary. But overall, we are also, of course, available for the questions by email as well, where you can explain your individual circumstances. I think I don't see questions. So with that, then we'll probably close this session. I will share the recording as well as the other details and the call also through our social media campaign, and it's available also on the web, so you can just go through and reach out if needed. With that, I want to say thank you to our speakers also who remain, and to Georgia for the presentation, and wish you a lovely, lovely afternoon and the rest of the week.